Well, since everyone got quiet, I will take that as the opportunity to start. Greetings, everyone. My name is Sally Richardson. I'm the interim dean here at Tulane Law School, and we are delighted to have you join us here this evening for the 2024 Dermot McGlinchey Lecture. This lecture honors a truly remarkable graduate of the law school whose legacy continues to shape the lives of all of our students in the law school, as well as all of our faculty and our staff. Born in New York City, Dermot McGlinchey received his undergraduate and his law degree from Tulane, graduating in the Tulane Law School class of 1957. While a student here at Tulane Law School, Dermot left his mark on the law school, and I mean that quite literally, as his name is actually etched in the back of the class before right here in room 110, having won our moot court competition, but he etched his name in many other ways as well at this school. For the next 36 years after he graduated from Tulane Law School, Mr. McGlinchey built a towering career in private law practice. And for all of those 36 years, he also gave back to his law school, to his university, to the Louisiana Bar, and to his community. At Tulane, he served as the president of the university's Alumni Association. He was on the Dean's Advisory Board here at the law school. He served as the vice chair of the endowment program for our Maritime Law Center, and he was the chair of the Law School Building Fund, the very fund that helped build this building that we sit in tonight. As a leader of the Louisiana Bar, Dermot McGlinchey fought for equal access to justice, and he helped to create the Louisiana Pro Bono Project, which so many of our students give back in their time and volunteer with every single year. This lecture that we hold tonight, it reflects another important legacy of Dermot McGlinchey, because he was also crafted, this lecture was crafted by the law partners of his firm at McGlinchey Stafford, the firm that he helped to found and build into one of the nation's finest law firms right here in New Orleans. Founded in 1974, the firm now operates in 17 different offices with a little over 140 attorneys licensed in 32 different states. After Mr. McGlinchey's passing in 1993 at the unfortunate early age of 60, his partners founded this lecture series in honor of the firm's charitable foundation. And since that time, this lecture has always been one of our signature events in the intellectual life of our law school, drawing some of the nation's most eminent scholars, jurists, and practitioners to this podium, like the scholar that we have with us tonight, Professor Stephen Vladeck of the University of Texas. But before Professor Vladeck comes to the podium, let me take a moment to recognize and honor members of Mr. McGlinchey's family who are here tonight with us. Fanula McGlinchey Monstead and her husband, Charles Monstead, thank you very much for coming tonight. Deidre McGlinchey and her husband, Hal Moffitt, thank you so much for coming this evening. All of the McGlinchey family has been long supporters of Tulane Law School and Tulane University. And without their continued support, we'd be unable to continue things like this wonderful lecture that have brought so many of you to this room tonight. And you have come not to listen to me, so I should get away from the podium at this point. But before I do, it is my delight and my pleasure to turn the podium over briefly to my friend, my colleague, Professor Steve Griffin, the W.R. Irby Chair and Rutledge C. Clement Jr. Professor in Constitutional Law, for him to introduce our speaker for you this evening. So Steve, take it away.
Let me extemporize by saying, as many of you know, we've had a wonderful announcement here at the law school of a new dean joining us next fall. But that also kind of means I'm a little bit sad. We're losing our interim dean, Dean Sally, who's done such a great job. Everybody knows it. So we could give her a round of applause. As if you've attended this in the past, you know I tend not to introduce our speaker by reading from the program, but by giving some extemporaneous remarks about why I chose the speaker and their importance. And by the way, it's really nice to see so many of you out here this evening. Professor Vladeck is the Charles Allen Wright Chair in Federal Courts at the University of Texas at Austin School of Law. And he is the author, most recently, of this book I happen to have. She happened to sign on, be good enough to sign the Shadow Docket, which has really put him in the news. But one of the reasons I knew to invite him, and I knew the book was going to be important, was that he's had a running commentary for many years now on how the court has changed. And I think he's going to talk a little bit about that, but it resonated with me because I've been inviting people for this lecture series, certainly who are eminent in constitutional law, sometimes in my home base of constitutional theory, but I'm reminded every year it was founded around the theme of federal litigation. And Professor Vladeck isn't just an expert on the Supreme Court, he's an expert on what's going on in our own Fifth Circuit and maintains a very close scrutiny, not only of the substance of federal litigation, you might say on the merits, but also on the procedural side as well. And it's this topic that's perhaps been a bit neglected in the commentary in recent years on the court. Everyone's so focused on the merits that they may have neglected to notice that the Supreme Court, not just recently, but also in the course of our history, has undergone several major changes, which really, in the course of time, transformed it into a different kind of institution than, let's say, the framers in the 18th century were familiar with, and even throughout much of the 19th century. So I felt it was a good idea to turn back our attention, at least for a while, on the issues of process and litigation. And when Professor Vladeck's book hit the shelves, I thought, well, this would be a perfect time to hear from one of the leading experts in not only the merits of constitutional law, but the process by which the Supreme Court renders its decisions. So without further ado, please welcome Professor Vladeck.
I asked Steve to lower expectations, so this is not off to a good start. Thank you, Steve, for that introduction. Dean Sally McCarthy, thank you so much, Dean Sally Richardson, Tony, who I think is out there somewhere, for all of her help setting this up. This is a real treat for me, not just because I get to come to the heart of the Fifth Circuit, where they have not yet cited me for contempt, but because anytime I get to come talk to law schools about the Supreme Court, I'm achieving one of my principal pedagogical goals, which is to change how we talk about the Supreme Court. So my quest in our time together tonight is to get you all to think about the Supreme Court a little differently, hopefully, than you already were, or you've read the book and you subscribe to my newsletter and you're already there, in which case, great. Okay, so many, if not most, right, of our public discussions of the Supreme Court tend to focus on what we might call the merits docket, the 60 or so decisions the Supreme Court hands down each term after briefing and argument, long opinions. We make you read them in your classes. Justice Kennedy once told me the problem with law school casebooks is that they over-edit his opinions. If you've read a Kennedy opinion, you know exactly why that's what we call chutzpah. But when the conversation's framed in those terms, we tend to fall into the same two traps. So trap number one is virtually every debate about the court ends up dividing us into tribes because those decisions tend to be so ideologically charged. And in the process, it obscures and otherwise crowds out public discussion and debate about other features of the courts and the justices' work that are unrelated, right, or at least not directly related to the merits docket. So, you know, no surprise, the Supreme Court has become a lightning rod, not just for its substantive decisions, but as more and more concerns have been raised about, oh, I don't know, plane trips and yachts and private school tuition. And while this is going on, public support, at least according to Gallup polling, has dropped to the lowest levels since polling on the Supreme Court began. These are probably not unrelated. And that in turn has prompted calls for reform. Those calls have provoked a rather interesting pushback led by the hero of my story tonight, Justice Samuel Alito. In an op-ed or an interview with the Wall Street Journal last summer, Justice Alito said, "I know this is a controversial view, but I'm willing to say it." Always a good start. No provision in the Constitution gives Congress the authority to regulate the Supreme Court, period. I am not making this quote up. He actually said this. Why am I being so sort of hard on him? Well, here's Article 3, Section 2, Clause 2. Just in case it wasn't clear, I put the important part in yellow and underline, right? But here's one provision of the Constitution that expressly gives Congress the power to make regulations, right, to the Supreme Court's appellate jurisdiction. So he's wrong, but he's a Phillies fan. We understand that. The point is not, right? I mean, this is the bigger takeaway. If I were here to tell you Justice Alito is wrong, we could all just go have the reception now. The point is not that he's wrong as a matter of constitutional text or historical practice or common sense. He is. It's that we're at a place where he's even willing to say this out loud. That this is in the zeitgeist, that the conservative response to efforts to reform the Supreme Court is Congress can't do that. And the broader idea that Justice Alito's statement reflects is that the Supreme Court is not and ought not to be accountable to Congress. And that is the sort of the theme here. That is the larger point that I am aiming to rebut. So what I'd like to discuss this afternoon is how historically Congress actually did hold the Supreme Court accountable. What has happened? Like, what are the symptoms besides Justice Alito's interviews in the Wall Street Journal of an unaccountable court? Why this is actually a bad thing, like whether you like what the court is doing or don't like what the court is doing, why we should all be invested in an accountable court. And because I try to never end a talk on a down note, how we might begin to fix it. Why we should not just sort of give up hope that this is an entrenched and irredeemable problem. I'm a Mets fan. I have to be optimistic, especially in March. Okay, so all of federal courts in 25 seconds. Here we go. Historically, there were a lot of ways that Congress controlled the court, that Congress used its powers over the court to leverage the court, to nudge the court, to push the court. So one, the number of justices. Right? Not anymore, but at least from 1789 until 1869, Congress used its power to change the size of the court as a way of shaping the court's direction. Justice Alito himself sits in a seat that Congress created in 1837. I guess he thinks he's unconstitutional. But this was, right, a lever. It was a way of pushing back. It was a way of exerting influence. Where the court sat, you probably haven't thought about this that much, but until 1935, the Supreme Court sat in the Capitol, not just in the Capitol, until the Civil War, in the basement of the Capitol. What does it say about which branch is more powerful when you're sitting in the basement, right? I don't know if any of you guys are still living in your parents' basements, but you're not in charge, right? This was not an accident, right? It was actually a big deal. It was sold as a means of giving the court more power and autonomy and independence when Congress finally appropriated funds for the court to have its own building in the late 1920s, early 1930s. This is a picture, by the way, of the old Senate chamber, right, where the court sat from 1860 to 1935. Yes, we're the Supreme Court. We sit in the old Senate chamber, but we're the Supreme Court. Okay. When the court sits, this is probably even more random, but the whole first Monday in October shtick, that's a statute, right? Congress set that in 1917. If you guys know your baseball history, you might know that there was no World Series in 1904 because the National League teams were scared of the American League teams. There was no Supreme Court term in 1802. Why? Because Congress was worried about the Federalists on the court messing with the Repeal Act, right? Congress like, hey, Supreme Court, you're not going to sit this year. Again, Congress using its powers over the court as leverage. Imagine if Congress did that today. Hey, Supreme Court, no 2024 term. You know, go on vacation. You're already going on vacations. Let's help you. Okay, this one actually I think is an even bigger deal. The court's budget, right? So you probably have not gone out and looked up the Supreme Court's budget request for any of you looked up the Supreme Court's budget request for FY 2024? This is why I'm a nerd. It's $151 million. All right, now if you know your Article 3 requires that the justices' salaries not be diminished. So that's $3 million. $148 million of leverage, right, of discretionary appropriations, of things Congress could do if it really wanted to leverage the court. Now, today, it's unthinkable that Congress would do this, right? But it didn't used to be. The justices' pensions actually used to be a huge subject of debate and control, so much so that Congress actually used to pass statutes like this one. If you can see it, great. If not, I'll read it to you. The statute is called an act to permit Ward Hunt, an associate justice of the Supreme Court, to retire. And it basically says, hey, if your name is Ward Hunt and you're a justice on the Supreme Court and you retire in the next 30 days, we'll give you a pension, right? It's like, guess what? Hey, guess what Ward Hunt did? Okay. Congress would do this. Now, Congress created a more permanent retirement system in 1937, which is actually a big part of the story of the switch in time that saves 9 and the sort of New Deal revolution. Van Devanter's like, fine, I'm out. But it was Congress that did it, right? Congress using its power over pensions as leverage. Okay, the justices travel, and I don't mean by yacht, but until 1911, right, Congress required the justices to ride circuit. This was including long past the time when this actually served any real legal purpose. Why do we make the justices ride circuit? Because they hated it. You probably never heard of Justice Thomas Johnson, right? Justice Thomas Johnson resigned after serving about 193 days on the Supreme Court, and he sent a nasty letter to the president who appointed him, George Washington, saying, you duped me. Right? You didn't tell me that this job was going to require traveling and that I'd have to pay for it out of pocket. That was Congress, right? That was, again, Congress leveraging the court. All right. But last and most importantly, Congress used to control the court's docket, right? Until 1891, every single case the Supreme Court heard was a case Congress told it to hear, right? The Supreme Court had no control over its docket until Congress in the very, very, very late 19th century first experiments with this crazy thing called certiorari, right? That was not the norm. What does it mean that the court had no control over its docket? It means the justices could not sit back and handpick cases. It means they actually had to decide everything, whether they liked it or not. So here's a chart. This is a lot of data, but this is the Supreme Court's caseload over time. Without even being able to see the bottom of the screen, you can probably guess where 1891 is on this chart, right? Meanwhile, look at where we are at the far right end, right? While all of this is happening, as Congress has given the court more control over its docket, culminating in 1988 when Congress said, hey, Supreme Court, do whatever, right? The court's like, great, we'll do less. Now, this might seem odd to you, right? The Supreme Court's in the headlines all the time. How can it be that the court is actually deciding fewer cases than at any point since the Civil War? Right? Do we call it the Civil War in Louisiana and Texas? We're not sure, right? A little bit of war of northern aggression going on the Texas side. It's New Orleans, right? So depends on what day it is. Okay. These things are related, right? And the thing that ties these threads together is a court that just does what it wants when it wants because Congress has stopped pushing back, because it is no longer worried about what would happen from Congress. Okay, now the point is not that Congress has complete and unfettered power over the court. Congress could not, for example, say, hey, Supreme Court, we'll give you the $148 million in your budget request if you overrule Dobbs. Sounds pretty good, right? But no. There's this Delphic but really important 1872 case that you've probably never heard of unless you've taken federal courts, called the United States versus Klein, where the court held that Congress violates Article 3 when it uses powers it otherwise has over the court to basically dictate how the court will rule. So there are limits on this. But there's so much room right, between what Congress can do and what Congress is doing today before we ever get anywhere close to those limits, right? Congress has and has historically exercised lots of constitutional powers to exert leverage over the court. And guys, all of the things we've been talking about, no one ever argued that they were unconstitutional, right? There was never serious suggestions that Congress lacked the power to do all those things. Okay, how did we get to where we are today? Well, so fast forward to the Alito quote, right? No provision gives Congress the power to do this thing that it's done constantly since 1789. But not just Alito. Here's Chief Justice Roberts politely declining to testify before the Senate Judiciary Committee in response to some of the reporting about Justice Alito and Justice Thomas. Quote, in light of separation of powers concerns and the importance of preserving judicial independence, right? So I'm not coming to testify. Chief justices don't do that sort of thing, except all the times in the past when chief justices did that sort of thing. The biggest shift in the Supreme Court's jurisdiction historically was in 1925. You may not know that colloquially, the Judiciary Act of 1925 is known as the Judge's Bill, but it's the justices who wrote it, led by then Chief Justice William Howard Taft, right? Taft was instrumental in converting the court's power. How did he do it? He testified before Congress a lot. Right? There's actually later in the letter, Robert's like, not counting times that we testified in support of court administration. Yeah, those kind of matter. All right. Other symptoms, right? Contrast Roberts's approach with Chief Justice Burger, who began delivering what's now called the Chief Justice's year-end report on the state of the federal judiciary in the mid-1970s. And for Burger, I mean, it was a couple of things. If you know your Warren Burger, he wanted his own State of the Union. Right? And so this was one way to do that. But it was also a means of inviting dialogue with Congress over judicial reforms. It was a wish, like the State of the Union, it was a wish list. Hey, Congress, here's what we need. Right? Every year, he and then Chief Justice Rehnquist, noted liberal William Hobbs Rehnquist, also used this report to ask Congress for things. Chief Justice Roberts continued to deliver the report, but in 2009, he stopped asking for stuff. Because if you ask for stuff, you're sort of inviting Congress to, do stuff. You might remember during the leak investigation, right? Chief Justice Roberts refuses to invite the FBI to come assist in the leak investigation because, no, we could investigate ourselves, thank you. Narrator, no, he can't. But, okay. These are all part of the same problem. Then we get to what the court's doing. So the merits docket, we talked about how the docket is shrinking and how the court is hearing fewer cases than at any point since the Civil War. It's taken longer to decide cases than at any recent point. So far this term, the court has handed down 9 decisions in argued cases. That's the slowest pace of any term since the court started in the first Monday of October in 1917. So congratulations, you guys are witnesses to history, right? Of the 58 signed opinions in argued cases last term, 57 were cases the justices chose to hear. Now you might say, okay, so what? Well, how many of you have read stories talking about how often the court was unanimous, right? The justices were unanimous in 26.6% of the cases, or my favorite, Sotomayor and Gorsuch, they were on the same side in 19% of the cases. None of those claims ever point out the very obvious selection bias, which is that these are the cases the justices chose, right? Does it tell us that much about the court, that based on the cases they chose, they made these decisions? Or to put the point a little more precisely, this term, the court has 11 cases from the Fifth Circuit. That's a lot, by the way. Good job, Fifth Circuit. Jobs program for the Supreme Court, right? If the court reverses most of those, as I suspect it will, and if the justices who are doing it are the 3 Democratic appointees and the 3 more moderate Republican appointees, is that telling us more about the court or the Fifth Circuit? We can debate that, right? It's not obvious just because of the numerical claim. Only one of those 58 cases was a direct appeal from a state criminal conviction. This used to be the bread and butter of the Supreme Court. Criminal procedure. There's a professor at Berkeley, Oren Kerr, who made his career out of the Supreme Court's criminal procedure jurisprudence. And I love Oren to death. His tweets these days are basically complaints about how the Supreme Court never takes criminal procedure cases anymore. Is that because we have solved criminal procedure? I suspect there are some lawyers in the room who can say, no, we haven't. But yeah, the Louisiana Supreme Court's all over it. Okay. More than that, right? The demise of a criminal appellate docket is not just bad for criminal procedure professors and practitioners. It has massive ramifications for civil rights plaintiffs and prisoners who often need law to be clearly established for them to be able to prevail in their claims. If the court's not establishing any law, then they're sort of SOL. And then this is a bit more in the weeds, but as relevant to some of my litigation work, the court has only had one argued case on a service member cert petition since 1996. That's pretty crazy when you think about how many courts-martial there are every year. So you can find lots of ways in which cases have disappeared from the court's docket and no one's noticed, except for Oren Kerr. Oren's noticed. Okay. Again, back to these trends. We also have the rise, right, of what Will Bode dubbed the shadow docket, sort of the non-merits docket, the orders that the Supreme Court hands down that deal with either granting or denying certiorari or granting or denying emergency relief. The court is continuing to grant emergency relief more often and with broader impacts than at any point prior to 2017, typically with no explanation. When I made the slides, this was the obvious recent example. This was from January, when the Supreme Court, by a 5-4 ruling, vacated an injunction that the Fifth Circuit had entered. Lots of words coming. Let me do this from the other direction. Texas was putting razor wire along the U.S.-Mexico border. The Biden administration was removing the razor wire. Texas sued the Biden administration. The district court said, no, you can't do that. The Fifth Circuit said, sure you can. Here's an injunction. And the Supreme Court vacated the injunction, basically saying, hey, Biden, go ahead, remove the razor wire. That's the order. That's it, right? If you guys are lost, it's like, that's a great reading assignment. I can do that reading, right? No explanation from the majority, no explanation. This has become much more common. Right before our lecture this afternoon, right? The Supreme Court let Texas's new immigration law go into effect for about 4 minutes. And then realized that they should probably not do that and put it back on hold. Chief Justice Roberts denied Peter Navarro's request, right, to avoid reporting to federal prison tomorrow. This is not historically typical, right, for the Supreme Court seemingly every day, not every week, having these big orders that are actually kind of important. And let me just make one other point that hopefully is going to sort of be obvious. I have yet to say a word about whether any of these decisions are right or wrong. Right? We haven't talked about ideology. We haven't talked about like the Commerce Clause, right? This is all procedural. The court is doing this even in cases like this one, where the Democrats are winning. It's not about ideology; it's about process. Okay. So hopefully I've persuaded you that the court is doing lots of stuff that suggests that it doesn't think it has to explain itself, that it's not worried about Congress, that it's not worried about pushback. There are other examples. Ethics. I'll leave that out there. Okay. Why is this a problem? So I suspect this audience does not need to be especially persuaded that an unaccountable Supreme Court is a problem, but let's do it anyway. So back to the Gallup poll, eroding public support for the court. Public support is critical because Justice Alito notwithstanding, the court's legitimacy depends upon public confidence, right? An illegitimate court can still hand down the same rulings, but who's going to enforce them? It wasn't the Supreme Court that desegregated Central High School in Little Rock. It was the Army sent by President Eisenhower to enforce Brown versus Board of Education, right? The less faith the public has in the justices, the less ability the court will have to hand down unpopular opinions. After all, this is sort of an exercise I do with my federal courts class. Who's bound by Supreme Court decisions? This is fun because it puts me in the position of defending Ted Cruz. So Ted Cruz, after Obergefell versus Hodges, said Texas was not bound, right, by the Supreme Court decision legalizing same-sex marriage, and technically he was right. Texas was not a party to the case. The Fifth Circuit was not one of the lower courts in that case. So Easy, right? The parties and the lower courts are directly bound by a decision. But why is it the case that lower courts and government officials in other cases are bound by the Supreme Court? Not because of contempt, not because of the law of the case doctrine, but because of public confidence in the court, because we all expect that if Texas were to continue denying marriage licenses after Obergefell, the Supreme Court would eventually have said that's unconstitutional, and that President Obama would have sent the army. That would have been interesting, right? It's how this is supposed to work. The Supreme Court's power is soft power. This is Justice Jackson in 1953. We are not final because we're infallible. No shit. We are infallible because we are final, right? That in other words, it's because the Supreme Court gets to go again in the second generation case, in the third generation case. Why does the court get to go again? Because it has appellate jurisdiction. Who gives the court appellate jurisdiction? Were we taking notes? No, we weren't taking notes. Congress, right, controls the court's appellate docket. So all of this gets back to the point that the more unaccountable the court is, the more unpopular the court is, the less reason there is for Congress, for the president, for all of us, right, to let the court have all of this power. And it's us who are letting them, right? Like we are acquiescing in this. Okay, so the broader point here, right, is this is why public confidence matters. Look at the razor wire order. So maybe this wasn't quite as big a deal in Louisiana. In Texas, right, there were plenty of folks on the left who accused Governor Abbott of defying the Supreme Court because he put more razor wire along the border. At some point, you ran out of razor wire. There were folks on the right, like Congressman Chip Roy, who said Governor Abbott should defy the Supreme Court. That's pretty remarkable, right? That we have members of Congress publicly arguing that governors should defy, that Republican governors should defy the Supreme Court. I don't think that would be possible, right? In a time when the Supreme Court was much more popular, in a time in which there was much more public confidence in the Supreme Court. All right, so all of this gets to sort of why there are serious costs to the erosion of accountability. Now the question becomes, what do we do about it? So some of us have been arguing about this and writing books and Substack newsletters and federal courts classes with exams that sometimes, don't go the way you expect them to. But here's Justice Alito. This is in a speech at Notre Dame Law School. I like that picture. Right. So recently, the catchy and sinister term shadow docket has been used to portray the court as having been captured by a dangerous cabal that resorts to sneaky and improper methods to get its ways. I really wanted to put that on the cover of the book, but my publisher said no. This portrayal feeds unprecedented efforts to intimidate the court or damage it as an independent institution, right? The idea is that criticizing the court is actually what's delegitimizing it, right? That actually it's an affront to judicial independence to be pushing for the court to be more accountable. Well, ultimately, if the justices are genuinely worried about the erosion of the court's legitimacy, and I hope they ought to listen to some of the criticisms being leveled against them and it, rather than just attack those who are making them. It's no exaggeration, I think, to suggest that democracy itself may depend upon a court that's still widely perceived to be legitimate in the months and years to come, as courts become the battlefield for fights over voter suppression laws, election integrity disputes, perhaps even legitimacy of results. That would never happen, right? We'd never have a Supreme Court in the middle of that stuff. And those who practice before the court should be among the first, I would think, not the last, to work towards cementing its credibility and legitimacy. And this is sort of to tie these things together. Yes, this is it is sort of a fine line, right? The Constitution enshrines judicial independence because we want to protect against tyrannies of the majority. We don't want Congress to run over the court, but it also enshrines checks on the courts to protect against tyrannies of unelected judges. And I think that's a point that's gotten lost in some of the recent defenses of the court's independence. The point is that not that the court should follow the election returns, to quote Dooley, but the court depends upon the democratically elected branches to function, to hand down decisions in the first place, to ensure those decisions are enforced, to turn the lights on in ways that I think we've forgotten, right? And so the court needs to be generally accountable in order to be independent, right? In order to have the capital, in order to have the authority to spend on unpopular decisions. Accountability thus facilitates the court's independence. It's not anathema to it. That's the big point that I think has gotten lost in the recent conversation. Why? Because we don't talk about the court this way. We're too busy fighting over, is this case right? Is that case wrong? So where do we go from here? All right, so there are lots of things we can and should discuss by way of reforms. I'm happy to talk about them more in the Q&A. You probably don't care that much. But just one really obvious, easy one is to force the court to decide more cases, especially cases that justices don't want. Right? Imagine a world in which the Supreme Court was deciding twice as many cases a year, including cases that lower courts wanted them to decide, but they didn't. Including cases that would otherwise provoke emergency applications, like last-minute challenges to the method of execution in those states that still have the death penalty. A meaningful ethics enforcement mechanism. Imagine that, right? Where whatever you think of the justice's behavior, whatever you think the rules ought to be, there's actually someone who's monitoring the justice's behavior other than ProPublica. And that person actually has the power not to punish the justices, but to publicly report on their compliance with the relevant rules, right? Taking pressure off the shadow docket, automatic stays of certain rulings, maybe nationwide injunctions, for example. There are lots of these. The point is not to get lost in the weeds, though. The point is that when we start changing how we talk about the court and what's wrong with it, the conversation shifts toward these reforms. Now, you might say, well, this Congress, nothing's going to change. Some things already have, right? So some of the public criticisms of the shadow docket have pushed the court to change its behavior on emergency applications. You might have noticed last month, the court heard oral argument on 4 emergency applications challenging the Biden administration's good neighbor ozone pollution standards. That was only the 3rd time the court had heard oral argument on an emergency application since 1971. The first 2 times were in 2022, right? Not a coincidence. The court is taking more of these high-profile emergency applications and kicking them to the merits docket. The case the court heard this morning, right, Murphy versus Missouri, in which Louisiana is one of the plaintiffs, right, about social media jawboning, came to the court first as an application for a stay. So some of this behavior started to change when there was pushback, when folks were saying, hey guys, it's not just the bottom lines of your rulings, it's the way you're behaving. That's a problem. And so this is really the takeaway. The problem is not that there are 6 Republican appointees or 3 Democrats. Someone asked me once what I thought that there were, there was a time not so long ago where there were, 6 Yale graduates and 3 Harvard graduates on the court. Someone asked me what I thought about that. I said, that's 3 too many Harvard graduates. By the way, Yale, go to the NCAA tournament. Thank you very much. Right. Nor is it that the court is handing down merits decisions with which many of us disagree, even when those disagreements are profound. Listen, if you think the Supreme Court has spent all of its history handing down brilliant merits decisions that we completely agree with, what court have you been reading about? Right? The court of Dred Scott and Plessy and Lochner is a court that is not that atypical in American history, right? This is not new. What is new about the court, what is different, what is really wrong about the court in this moment is not substance, it's the lack of accountability. And that's not ideological, it's institutional, right? Maybe we're seeing it more because of the current ideological division on the court. Maybe we're seeing it more because of the hollowing out of the middle on the court. But that's just a visibility point. All right, so these reforms might seem elusive, if not illusory, but we already have examples of pretty rapid shifts in the relationship between the political branches in the court at prior moments in American history. Reconstruction, things changed very quickly. 1937, all of constitutional law flipped on a dime, right? And unlike a debate cast entirely in ideological terms, a debate about the court's proper institutional role ought to be a debate that unites folks across the political spectrum, or at least doesn't divide us directly down those lines. And so that's why I wrote the shadow docket. It's why I write a weekly newsletter about the court called One First, because I couldn't come up with a better name. And the Supreme Court's mailing address seemed good enough. And it's why it's such a privilege to be giving this year's McGlinchey Lecture. And I would love to take your questions. Thank you very much.
I'll practice take a few questions after the lecture, just keeping in mind that After the Q&A, we're going to have a very nice reception on the NPR, and everyone, especially the students, I hope will have a chance to ask further questions of Professor Vladeck, but I've got one from the procedure. Just yes. Question.
Okay, so back in the 90s, the Rehnquist court did hear many more cases, I think, than they hear now. Interestingly, our present chief clerk for Rehnquist, right? So do you have any reflections on how that change occurred over time while we weren't watching, and or whether or not, what factors might, push the court toward taking back that docket of maybe 120 decisions they used to?
Yeah, I mean, I think it's no one thing, right? So the Rehnquist court, there's this remarkable shift. So to tell the story in sort of a little bit more detail, right? So 1925, Congress gives the court for the first time broad control over its docket, but it's really 1988 when Congress gives the court almost plenary control. Today, guys, the only cases the Supreme Court has to hear today are appeals from what are called 3-judge district courts. Those are required only in campaign finance cases and constitutional but not statutory challenges to congressional redistricting. Right, just to sort of illustrate this, the Alabama redistricting cases were 2 cases. One went to a 3-judge court because it was a constitutional challenge. Okay, anyway, there aren't that many of those, right? Last term there was 1. Instead, it's mostly cert. So that was true by the mid-90s. And that was true by the era when, a whole lot of folks who are currently in legal practice and the law schools were clerking on the court. But then you still had, right, a robust middle of the court. You had not just Justice Kennedy and Justice O'Connor, but you had Justice White, right, at the beginning. You had Justice Souter. And so I think there was this sort of inertia about granting cert in cases that had no particular ideological valence, but were just important. And I think one of the things that's really reflected in this continuing negative derivative, right, on the far side of the chart is as the middle has emptied out, now all of the grants come from one side, right? I mean, just as a math problem, right, it is no longer possible for the Democratic appointees by themselves to force a cert grant. It takes 4. Every case the Supreme Court hears today has at least one of the Republican appointees voting to hear it. So I think that's part of it. I think there's a lot more defensive denials where justices are just not taking cases that meet the court's criteria because they're not sure what the court's going to do with them. And, I think that there's just no one inside the court pushing back. This might be a strange point to make, but I think it's worth saying. The justice who dissents the most frequently from denials of certiorari is probably not who you're probably expecting me to say, either Justice Thomas or Justice Sotomayor. It's Justice Kavanaugh. Right? He seems to be the only justice who thinks the court as a whole should be taking more cases. And maybe one day he'll actually say that. But so I think it's all of these factors mixed together and no one pushing back, right? No lower court saying, hey, Supreme Court, we need more of this. No Congress saying, hey, Supreme Court, why are you hearing 55 cases a year? I think it would be interesting if we had that conversation.
Yeah, I'll follow up, and I hate to confess in front of all my colleagues that I don't actually read every opinion, but the ones I do read, I kind of get the sense they're writing more. Do you think they're writing more about less?
Yes. So there's good scholarship about this. The average opinion length is way up. Probably not surprising, right? What's the Mark Twain line? I apologize for the length of this letter. If I had more time, it would be shorter. Right. So average opinion lengths are up. I leave it to you to decide whether that means average clarity is up. I'm just going to respectfully dissent on that one. And I mean, I think it's worth stressing. The other thing that's happening behind the scenes is with the, for lack of a better word, certification. Well, that's a bad word. Okay. With the certiorization of the Supreme Court's docket, much of this stuff has moved behind the scenes. Where now that we know, right, from internal reporting, we know from the court's own sort of public statements that these days only about 3% of cert petitions even get discussed at the justices' conference. 97% of cert petitions never even make it to conference. What that tells me is that the justices are spending a lot of time thinking in advance about their docket. You can see this in opinions that say, hey, we're not granting cert today, but if a case were to happen to come along that raised this issue, great. The obvious, but I think important point is, right, there's more strategic behavior when you're not sort of playing triage. When you have a month to write a research paper as opposed to 36 hours, which paper is going to be better? You guys are like, well, yeah. So they're writing more, but the writing more is also they're being much more strategic in ways that when the docket was more crowded, they had less of an opportunity to be. And I think that's, we don't see that reflected publicly, but it's unquestionably part of what's happening behind the scenes. No.
Yeah. So I want to do a little apologetics for Alito and say that
The Phillies are fine.
well, it's you want to take his statement that the court ought not to be politically accountable, whereas I would read it more as like it's more a stance of it is not, and so it's like okay, so all of these big times where Congress has flexed its muscles against the court. I mean, you got the founding, you got McCardle and Yerger after the Civil War. You got Wickard in the New Deal, and so what it kind of requires is, I mean, put it bluntly, an American Caesar. I mean, you've got Washington in the beginning, you've got Lincoln, and you've got FDR. So in order to hold the court politically accountable, don't we kind of need to be politically unified in some way? And so the court, I mean, no one here, I'm guessing, really wants Orange Caesar back. But I mean, but in a real sense, it's like that's, I mean, you talk about overturning Dobbs. It's like, I mean, if we would say, oh, the country's politically united behind a right to an abortion, we would have either had a national law saying so or a constitutional amendment. And so, I mean, I would say Alito's kind of calling our bluff a little bit. It's like, we can't hold us accountable unless you get your shit together.
So, I mean, I think there's something to that. First, I mean, I think that is a very, very generous reading of his remarks. But let's assume that it's a fair one. First, I mean, I think Congress has been more active than just in those moments, right? That yes, the most visible flashpoints in the canon are flashpoints of sort of historical magnitude, right? Reconstruction, 1930, I mean, the New Deal, et cetera. But, the Ward Hunt bill, right, is in the 1880s. We don't really talk about that. Congress is actually really active in messing with the court's jurisdiction in the 1890s, right? We don't really talk about that much. When Taft comes along and does his thing, it's the 1920s. I don't think everyone's really sort of fired up about the Harding administration in this context. So, I think the history is a little less episodic, right? The broader point, though, is I don't know that we have to be, the political unity point suggests to me that it's coming in moments where the court is standing up against the political majority on a whole host of issues. That gets you the New Deal, that maybe gets you part of Reconstruction. And I think that buys into what to me is the problem, which is thinking about the conversation only in terms of the bottom lines of what the court is doing, right? As opposed to the sort of the structural relationship between the branches, where I think actually historically we saw Congress pushing back both when there was divided government and when there was not, right? I mean, it was Democrats in Congress who really killed FDR's court packing plan as much as it was Republicans. So I think, to me, the sort of the notion that it's only going to come when there's sort of political uniting against the court is a world in which, again, we're thinking about the court purely by dint of what it does on the merits. And I think that that's the exact trap that we've fallen into, partly because of how we teach it.
Some of the reforms aren't so much that you suggest aren't so much pushbacks against the court. They're efforts to make the court more credible.
I mean, which again, I mean, so one of the things I've been struck by, I've been beating this drum for 7 or 8 years now, and I've been struck by the sort of the lack of buy-in from the sort of the court's more visible conservative defenders. Because I would think that if you were invested in long-term, right, hegemony of the court, this would be a big problem. If instead you were of the view that, you've got the votes now, don't miss the opportunity, maybe you come out differently. And so I think that's part of what's, messy about the moment we're in.
Let's take 2 more. I got Jimmy Nisa, I think, back there.
Thank you. You have law students, law professors, and practitioners here this afternoon. And other than coming to listen to a fascinating lecture, thank you. and buying your book and perhaps even reading it.
My wife hasn't.
What do we do?
So I mean, listen, you're here, like, hey. So I think that to me, I mean, part of my goal, as I mentioned at the very top, was to get all of us to start talking about the court a little differently. And, you know, I don't know how much time you guys spend outside of, you know, Monday afternoon lectures talking about the Supreme Court. But when you do, right, you know, I think it's really important to actually be a little more holistic in how you think about the court. Right? Is the court right or wrong just because you like the decision or you don't like the decision? Are we paying attention to what the court's doing in the less visible cases? Right? Those of us who are teachers, right? Are we actually showing our students the institutional side? Those of us who are students, are we seeing the institutional side? Those who are practitioners, right? When we're out in the world at bar events or CLE, or do we have CLE in Louisiana? Yeah, right. Texas is not sure about this, right? So, you know, but like this starts small, right? But it starts by getting us out of the mindset that the Supreme Court should be viewed purely by reflection of what it does on the merits. And the more that everyone's having that conversation, I mean, I'll just give you guys one really, really dumb example. The casebook that I teach federal courts out of is sort of the founding casebook of the field. It's called Hart and Wexler's The Federal Courts and the Federal System. Please hope that you are never exposed to that in your lives. Although in his judiciary committee, so John Roberts, when he was nominated to the DC Circuit in 2003, there's a question like, you know, what book has inspired you professionally? And his answer was Hart and Wexler, which is the most like apple to a teacher answer, right, to that question. So Hart and Wexler, right, which is, you know, for better or for worse, the sort of the field defined in casebook for federal courts, used to have a chapter on the Supreme Court's docket, and on the certiorari, and part of that was the certiorari process. And that chapter fell out after the 4th or 5th edition in the 1990s. They're putting it back in the 8th edition, right, which is coming out next year. It's little stuff like that, right? It is sort of moving folks. I now see, just another dumb example, I now see when you see news reports about unsigned, unexplained orders, you'll see them saying there were no public dissents, right? Or there were 3 public dissents, reflecting the fact that the press now understands that actually you can have stealth dissents. These are all little points, but they're part of the broader sort of theme that just don't just think that the court is the sum total of its decisions. And I think the more that we can have conversations like that across the field, the more that, you know, not tomorrow, but maybe in a few years, we'll be thinking and talking about the court differently in more constructive ways.
Yeah, let's do one more.
Yeah, so what if the relationship between Congress and the court is the way it is because Congress likes it that way?
So Brian, I think that's a great question. I don't doubt that it's partly because this Congress likes it that way. One of the ironies is I suspect a common reaction to any time that someone says it's Congress's fault is to blame polarization. It's a polarized Congress. There's no responsible middle. Nothing's going to get done except when there's divided government, right? Like that mentality. It turns out Congress taking its hands off the Supreme Court predates, right, our modern polarization. And I think actually was, Brian, very, very much reflective of a Congress that was not necessarily happy with the decisions the Supreme Court was handing down, but institutionally content with the court's behavior. And that's a process that took decades, the 50s, the 60s, the 70s, when the court had a well-tended middle, right? When you had John Marshall Harlan and Potter Stewart and Lewis Powell. And, you know, I think that's a big part of why Congress took its foot off the brake. I suspect, right, that if you actually got Congress away from microphones and television and stuff, this Congress would actually say, oh, no, we shouldn't have institutions with unchecked power. I mean, when we talk about this in the context of the executive branch, right, we have no trouble, especially when the president's from a different party, saying, oh, the executive branch has too much power. But why are we at a point, right, where the executive branch is left to do so much through executive order because Congress has stopped legislating? The same is true of the court. And so I think part of the phenomenon here is suggest that if you actually were to, you know, I don't know what, give Congress truth serum, they'd probably say this is terrible. And my one example of this, just to illustrate this, Congress has had 2 hearings to date on the shadow docket. One was in February of 2021 when no one was paying attention to it. And it was a House Judiciary Committee hearing that was on Zoom because of COVID, and it was just like got zero public coverage. And it was super substantive. There were Republican members saying, oh, maybe we should reform the standards for emergency relief, right? There were Democratic members saying, this term is pejorative. I'm like, shadows are the natural result of, okay, anyway. Right? Because it was not sort of visible, it was actually quite useful. The other hearing was in September 2021, 3 weeks after the Supreme Court allowed Texas's 6-week abortion ban to go into effect. And the hearing was called Abortion in the Shadow Docket. Guess how that went? Right? The Senate Judiciary Committee spent the whole hearing with Republicans talking about why Roe is wrong and Democrats talking about why Roe is so important, and no one talked about the shadow docket except me. I did, but Brian, that says to me, right, that if you can actually make this about serious institutional conversations, there are plenty of members of Congress in both parties who actually could be persuaded that there's work to do. And the goal is actually, again, to shift from, one side good, other side bad, right, to institution bad. There's an old story that I learned this from the West Wing, but it turns out this is true. Right, I think it was Sam Rayburn tells the story about a junior colleague who comes to him and says, all right, I'm here, right? Show me the Republicans. I want to meet the enemy, right? And Rayburn puts his arm around him and says, son, the Republicans aren't the enemy. They're the opposition. The Senate, that's the enemy, right? We don't think like that anymore. And I think that these are symptoms of that disease. We're used to talking about those symptoms in the context of congressional dysfunction and executive branch power. We haven't been talking about that from the perspective of why this Supreme Court, which is taking fewer cases than the Civil War, is so in the middle of so many parts of our contemporary public discourse, and whether in the abstract that's a healthy thing.
All right, well, I think that's an excellent place to stop, but keep in mind, we have a wonderful reception for you. Thanks so much.